Hi, good evening. This is Xueyan from Chongqing. Today, I'm going to give a brief introduction to China's new foreign investment law that was enacted last year. Actually, I was originally supposed to talk about a chapter of a book that Professor Madinico and I co-edited. The book is called A Legal Analysis of the Belt and Road Initiative Towards a Silk Road. And the chapter I wrote in it is about political risk insurance. But in the end, I realized that topic would be too much to fit into a 15-minute lecture. So today, I'm just going to focus on China's new foreign investment law. But before we talk about the new foreign investment law, I'd like to give you some background information about it. China's foreign investment legislation can be traced back to 40 years. In July 1979, the second session of the Fifth National People's Congress passed the first law regulating foreign investment, the law on Sino-Foreign Joint Ventures, which marked the beginning of China's foreign investment legislation. The law on wholly foreign-owned enterprise and the law on Sino-foreign cooperative enterprises were subsequently promulgated. These three laws laid down the legislative framework for China's foreign investment. Over the past 40 years, the three laws have played a very important role. However, they were not able to meet the needs of this new era. Firstly, there were many problems regarding China's law and policy on market access, market competition, and government management services, which made foreign investors lack confidence in making long-term investments. A market environment of equal competition was urgently needed by enterprises with various ownership systems. Secondly, from a domestic perspective, China's economy has shifted from a stage of high-speed growth to high-quality development. The development of strategic emerging industries, high-end manufacturing, and modern service industries need to accelerate. Institutional mechanisms need to be further reformed and innovated, and the economic efficiency of state-owned enterprises urgently need to be improved. In addition, China's foreign investment policy is driven and constrained by the environment and the global capital flow trends. At present, the global investment situation is depressed. The investment policies of the major developed economies tend to be conservative, and the investment protectionist policies of the United States have gradually been implemented, affecting the flow of cross-border investment. Under this situation, China's traditional competition advantages have been gradually weakened, and new competitive advantages have not yet been formed. Under these circumstances, the new foreign investment law was enacted. It's noteworthy that the new law gives particular attention to the protection of intellectual property rights. The old three laws did not make any direct mention of protection of intellectual property rights, while the new foreign investment law pays special attention to the protection of intellectual property rights of foreign investors and foreign invested enterprises. In recent years, As you might have known, China has been accused of forcing technology transfer by many countries, including the United States. Article 22 responds to foreign countries' concerns regarding the forced transfer of technology. It stipulates that the conditions for technical cooperation in the process of foreign investment shall be determined by the investors through consultation and administrative organs, and their staff members shall not use administrative means to force the transfer of technology. The new foreign investment law also emphasizes the protection of trade secrets, which was not mentioned in the original three laws. According to the new law, administrative organs and their staff members shall keep confidential the trade secrets that they come to know in the course of performing their functions and duties, and shall not disclose or illegally provide them to the others. Another thing that is worth noting is that the new law requires local governments to keep the promises. In order to attract investment, it is common for local governments to promise preferential treatment. However, after the investments have been made, some local governments have not abided by the agreement. If the policy commitments were made by local governments in the forms of red-headed documents or leaders' speeches, which were not included in the contracts, investors often could not get support from the courts when they sued, which negatively affected not only the interests of the investors, but also the image of the governments. Article 25 requires local governments to abide by not only contracts but also policy commitments, which may change the adjudication of relevant cases in the future. Another point is that the new law adopts a negative list approach at the market access stage of foreign investment. The negative list embodies the legal concept of unless prohibited by law, it is permitted by law. The opposite concept is a positive list, under which market participants only have access to the area listed in the positive list. The positive list approach is clear and risk controllable for the host country. In the negotiation of international trade and investment agreements, as far as the level of commitment is concerned, the negative list approach generally indicates a higher level of openness than the positive list approach. After deciding to opening up to foreign investment and taking into account its own weak economy, China, like many other developing countries, adopted the positive list approach according to the policy of gradually opening up to foreign investment. The inclusion of the negative list approach in the new foreign investment law demonstrates China's positive attitude and willingness to actively promote the development of globalization through further opening up. Last but not the least, the new law emphasizes equal treatment between domestic and foreign investment in many ways. Equal treatment has always been a demand of foreign invested enterprises. The new foreign investment law stipulates that all policies of the state that support the development of enterprises are equally applicable to foreign invested enterprises. In addition, the state guarantees the fair participation of foreign invested enterprises in government procurement activities. These are the most critical areas in which the principle of competition neutrality being implemented, and they are also the issues regarding which foreign invested enterprises tend to lodge the highest number of complaints. To sum up, this new law attaches great importance to protecting intellectual property rights. It legally binds local governments dealing with foreign investors to keep their promises. It adopts a negative list approach at the market access stage of foreign investment, and it emphasizes equal treatment between domestic and foreign investment in many ways. In this very short lecture, I have just emphasized a handful of the most important articles of this legislation. But of course, there are a lot of other issues I haven't had time to talk about today. But overall, I would say that the foreign investment law marks China's new era of the promotion, protection, and management of the foreign investment. If you are interested in reading all of the legislation, I'm sure you will be able to find the English version online. That's all for today. Thank you for your attention. Goodbye.